everyone, Lee Pacchia here, and you are watching Between the Lines, part of Fault Lines look at the cracks in America's criminal justice system. We're talking to Chris Seaton today. He joins us over Skype from his home in Tennessee. Chris, good to see you. Thanks for joining us today.
Good to see you too, Lee, and welcome from the Scruffy City.
Right on. You have an article up today on Fault Lines that I thought was really interesting, and I thought it would be a good point of discussion for us. Basically, it talks about a proposed bill in the state of Vermont that would allow warrantless searches of cell phones. Can you unpack it a little bit for us?
Oh, the Green Mountain State deciding to figure out ways to get around Riley. For those
Well,
people,
let's do this. What's Riley first?
okay, Riley v. California was a decision held by the United States Supreme Court that dealt with the warrantless searches of cell phones when it comes to a search incident to a valid arrest. Previously, cops had been able to search your cell phone based on two prior case decisions, Kimmel v. California and United States v. Robinson. The Kimmel case said that if an officer has arrested you, they're allowed to search your person absent a warrant for anything within your wingspan, just in case there's a weapon that you may have or something dangerous. United States v. Robinson went on to say that if there was a container on your person, then the police could search that as well, incident to a valid arrest. So what you ended up having were police arresting people and then taking things like this and treating them as containers, which at its face value seems a little bit bizarre because something like this, a deck of playing cards, is a bit more of a container than a cell phone would be, at least to most rational people. And then Riley v. California was the case where the Supreme Court, in an opinion articulated by Chief Justice Roberts, no less, said, and I quote, "Our answer to the question of what police must do before searching a cell phone seized incident to an arrest is accordingly simple. Get a warrant."
So what they're trying to do here in Vermont is, I mean, from my vantage point, I got to say, this law doesn't look like that bad an idea. It's just going to allow arresting officers, or even if it's just a stop, cops can look at your cell phone to see if you've been texting while driving or paying too much attention to Twitter or what have you. That's done for the purpose of saving lives. I got to say, this isn't a law, at least on first glance, that really got my blood boiling.
Yeah, well, you know what they say about the path to perdition being paved with good intentions, Lee. This particular bill was sponsored by a representative named Martin LaLonde, who is a former environmental lawyer and clerk to two federal court judges, which means he ought to know better than something like this. And what it does is it is a guise under. It's a bill crafted under the issue of public safety. Vermont currently has a statute that bans the use of portable electronic devices while driving. If you are caught using a portable electronic device, then you are subject to a couple of $100 worth of a fine and a couple of points on your driving record. Now, distracted driving is a big problem. We're not going to deny that. There's been a lot of studies that have shown that distracted driving is just as much of an impairment as drunk driving. What is really troubling about this, though, Lee, is that Representative LaLonde's bill is seeking to insert an implied consent aspect into this ban on Vermont's use of cell phones while driving. Basically, what that means is if you're driving through Vermont, you have implicitly consented to having your cell phone searched in the event you're stopped by a cop to see whether or not you actually have been texting while driving or, say, checking Twitter a little bit too much. If you refuse that search, then you are found in violation of the law and you get a couple of $100 fine and a couple of points on your record. Big problem with that, though, Lee. Data on a cell phone doesn't go away in the same way that alcohol does in a person's system. And that's where the problem lies. Because this is based off of implied consent laws concerning driving under the influence. And that's just enough of a line, at least from this attorney's opinion, to put a hole in Riley that's going to cause some very severe
All right,
problems.
so give me a hypothetical here. Your client, client A, gets pulled over. They search his cell phone to see if he's been, checking email or drafting texts. Where does this go off the rails? What's the nightmare scenario you're worried about?
Well, the nightmare scenario is this: there's nothing inside the proposed text of this bill that specifies how long the police are able to actually look at the phone, what they're supposed to be looking at, when they're supposed to return it to you. There's no exact scope that helps a cop determine whether or not this is just a violation of the no using your cell phone with your hands while you're driving ban in North Carolina and Vermont. Excuse me. They can basically take the phone from you, go back to their squad car, search through everything inside the cell phone for as long as they want, and then come back and potentially arrest you for something else. And that's what gets scary, because they can stop you under the pretext of saying, "Hey, I noticed you were texting on your cell phone. In Vermont, we're allowed to search your cell phone. Do you mind if I take a look?" And if you refuse, you get fined a couple $100 and have some points on your record. If you consent, then, well, police just absolutely love traffic stops, because they can sit there and sift through things on your cell phone until they find something that they can charge you extra with. And that's where it gets really problematic.
So what do you do here? Do you try to fix this bill? Can it be fixed? Or you just chuck the whole thing in the trash?
Well, the funny thing is about this, Lee, is that nobody outside of Martin LaLonde in his office seems to think this is a good idea. No, you laugh, but I'm serious. The Vermont Highway Patrol Division, various law enforcement groups inside Vermont, other legislators, they've all said, it might be a better use of our state's time and resources to actually educate the public on the dangers of distracted driving and do things to help prevent it, instead of doing stuff that could essentially get us in trouble. And even the law enforcement community has said, we have looked at the text of this bill, and if you're going to give us something, we have to know exactly how to enforce it, and we have no idea at this point based on this particular text. I say personally, as an attorney, Martin LaLonde needs to get smacked on the wrist. This bill needs to be scrapped. And if he's really that concerned about distracted driving in the Green Mountain State, he needs to come up with a better way to do it than this.
But it sounds like that's what's going to happen here. It doesn't even sound like this bill's going to pass to hear you talk about it.
I really hope not. I really, really hope that the legislature in Vermont has some common sense and does just kill this bill completely, because if they don't, then the ramifications are just outstanding. There's going to be more defendants inside Vermont's criminal justice system. There's going to be intense scrutiny outside Vermont. We could end up with, a challenge to Riley at the Supreme Court based on one person trying to do something good in a very bad way. My colleague Scott Greenfield, he always likes to quote H.L. Mencken: "For every complex solution, there is an answer that's clear, simple, and wrong." And Martin LaLonde's proposed bill is definitely the epitome of that.
Well, I, for one, am looking forward to the day where we don't have to pass legislation on distracted driving, because we're all going to be replaced with driverless cars sometime soon. I hope. Fingers crossed, at least.
I, for one, welcome our Skynet overlords.
Chris, always a pleasure. Thank you for taking the time today, sir.
Pleasure is definitely all mine. Thank you very much.
So you can read Chris's article on fault lines, which of course is at mimesislaw.com under the fault lines tab. If you'd like to see more of the stuff we're working on, go check out our site. It's absolutely fantastic. We're on Facebook, LinkedIn, Twitter. We're all over the place. If you're listening today over a podcast, do us a favor, write us a good review on iTunes. It makes all the difference in the world. And if you're watching us on YouTube, subscribe to our channel. There's more good stuff coming. I promise. I'm Lee Pacchia. Thanks for watching. Makes New York City's cops almost look European by comparison. Lots of problems. We're going to drill down today on something that I thought got a little bit overlooked in the news flow, and that might be because we're lawyers and maybe we're a little bit more sensitive to this kind of thing. But I want to talk about the case of Jordan Marsh.